If you've ever lived in a neighborhood with a homeowners association, an HOA, you know that little disagreements can pop up over pretty much anything. But what happens when a seemingly simple backyard dispute, we're talking about a single tree and a wall, spirals into a multi-year legal showdown? Well, we're about to find out.
This is the question at the heart of it all. Who pays when a tree starts causing damage? On the surface, it seems pretty straightforward, right? But as you'll see, this one question kicks off a whole legal journey that all comes down to some very specific, very tricky wording. It really shows you just how complicated neighborhood rules can get.
So let's set the stage. On one side, we have the homeowner, Travis Prall, and on the other, his HOA, the villas at Tierra Buena. This whole thing started with a tree root cracking a wall, something that seems pretty minor, but it quickly escalated into a full-blown, formal legal hearing.
And look, this thing didn't just happen overnight. It was a slow burn. Mr. Prall buys his home way back in 2010. 4 years go by, and a storm knocks the tree over. He has it removed. But then you fast forward to 2018, and that tree has grown back with a vengeance. Its roots are now damaging a wall, and that's when the official letter from the HOA arrives. And that right there is where the legal battle really kicks off. Now here's where it gets really interesting. Both Mr. Prall and the HOA were totally convinced they were in the right, and they were both basing their confidence on the exact same document, the community's official rulebook, the CC&Rs. So the big puzzle is, how could two parties read the same exact text and come to completely opposite conclusions? All right, let's get into the weeds of this rulebook, because this is where it all happens. The first key term is public yard. It's defined as any part of a yard that's, visible from a neighbor's property. Mr. Prall's backyard had a low fence, so it was clearly visible. For him, this was an open and shut case. It's a public yard, so it's the HOA's problem. But wait a second. The definition for private yard throws in a huge plot twist, and it's all thanks to one tiny little word, or. A yard is private if it's enclosed or if it's shielded from view. That one word, or, creates just enough ambiguity to start a massive legal fight, and you bet both sides were ready to run with it.
So here's exactly how those two different arguments took shape. Mr. Prall, the homeowner, he focused on the visible part. He said, look, you can see my yard, so it's public, and the HOA has to take care of it. But the HOA, they zeroed in on that other word, enclosed. They argued that because the yard had a fence, it was enclosed, period. That makes it a private yard, and that makes the tree his problem.
But the judge, she saw through all the back and forth about public versus private. She found the real answer hidden in a totally different part of the rules, a section detailing the HOA's duties. And the phrase that ended up deciding this whole thing was, as originally installed by declarant. And declarant is just a fancy legal word for the original developer who built the neighborhood. This was a really sharp move by the administrative law judge. She basically just cut through all the confusing arguments about fences and visibility. Her logic was simple. It doesn't really matter what you call the yard if the tree itself was never the HOA's responsibility to begin with. And boom, this became the one question the entire case hinged on. The burden of proof was now squarely on the homeowner, Mr. Prall. He had to come up with actual evidence, real proof, that his tree was part of the original landscaping that the developer installed way back when the neighborhood was built around the year 2000. So check out how the judge just completely dismantled the homeowner's argument. Mr. Prall's whole point was that the tree was big when he bought the house, so it must be original. But the judge pointed out that the same tree grew back to a pretty large size in just 5 years after 2014. That one fact completely undermined his timeline. So without any hard proof, his entire argument was just an assumption, not actual evidence. So the first verdict comes in. Mr. Prall failed to prove his case. His petition was dismissed. It looked like a clear win for the HOA. But this story was not over yet. Mr. Prall requested a rehearing, which set the stage for round 2. Okay, so now we get to the rehearing. And this time, the HOA came prepared with a totally new strategy. They weren't just going to argue about the rules again. No, they brought a key witness to the stand. And this move would completely change the game.
Meet Maureen Karpinski, the HOA's secret weapon. She wasn't just the board president, she was also one of the original real estate agents for the developer back in 2002. Her testimony was absolutely powerful. She recalled that all the homes, including her own, were sold with nothing but dirt in the backyards. No grass, no trees, no sprinklers. Just dirt.
And right there, that's the crucial difference. This wasn't someone else's interpretation of the rules. This was a direct, first-hand account from somebody who was actually there at the beginning. Her testimony went straight to the heart of the judge's big question about that original landscaping. So now, the contrast between the two cases couldn't be more clear. The homeowner's entire argument was built on guesswork, assumptions about the tree's age, about the irrigation system. But the HOA? They now had credible eyewitness testimony. And in any legal setting, that kind of direct, first-hand evidence is an absolute game changer.
And you can see it right here in the judge's own words from her final decision. She says, and I quote, "The only credible evidence offered was the testimony of Ms. Karpinski, who stated none of the homes had any landscaping installed in the backyard. They were just dirt." That testimony directly blew the homeowner's entire case out of the water.
And that was that. The final word. The evidence proved the tree wasn't original. And because of that, the whole public versus private yard debate became totally irrelevant. The responsibility for that tree and the wall it damaged fell squarely on the homeowner. So yeah, it's a fascinating local dispute for sure, but the implications here are so much broader. For literally anyone living under an HOA, or really in any community with shared rules, this story is a super valuable roadmap for how to navigate these kinds of conflicts. So what are the big lessons we can take away from this whole battle over a single tree? Well, first, read your documents inside and out. The answer is almost always hiding in the fine print, and a single word like "or" can change everything. Second, understand the burden of proof. An assumption isn't evidence. Mr. Prall assumed his tree was original, but he couldn't prove it, and the responsibility to prove it was on him. And finally, first-hand evidence is king. The HOA's case was pretty weak until they brought in a credible witness. And as we saw, that one piece of testimony was all it took to win the entire case.